So hello everybody, my name's Fiona Hewitt. I'm an employment partner at Constantine Law and I'm joined by my esteemed colleague Catherine Wilson, who's also an employment partner. And today we're going to be talking about what you need to know from an employment perspective if you're either setting up a new business or you're expanding. We're probably going to concentrate on more on setting up a new business, but a lot of what we say will apply to if you have plans for expansion and additional recruitment. So Catherine's going to first of all talk about what to look at before even the recruitment stage, and then I'm going to look at what happens on recruitment or just before recruitment, and then we're going to talk a little bit about what happens as we move forward in the employment relationship, and then right at the end we'll just touch on a snapshot of what we're looking at potentially in the future. So I hope you enjoyed today's podcast. And Catherine, first really thing over to you to talk about what our contacts need to know or might need to know about taking on people when they are, well, before the recruitment process.
Thanks, Fiona. I think the first thing to say is it's obviously really exciting when you've set up a business and you realise that you're about to feel you need to recruit somebody. And this may seem like pretty obvious, but we do see this quite frequently. You need to work out initially, what do you actually want? There needs to be some clarity, don't you agree, Fiona, about what is the job role and what is the job description? This isn't just a paper exercise. If we don't really know what the job role is and or the content of the job, it's incredibly difficult to make those correct recruitment decisions.
Definitely.
And often we see, I think that there's a sort of an uneasy balance in terms of these job descriptions between setting the bar very low and something totally generic that really means nothing, and what I would call a bit of a wish list. These are non-exhaustive, but there needs to be some reality check that you're actually asking the right types of questions and you know what you're really looking for.
Yes.
I think this is doubly important because getting that right person is so crucial. I think it's also, I'm not wishing to frighten anybody, but don't forget as well that there is a legal process around the recruitment. And if we don't know what we're recruiting, it's much more likely, for example, that we could face the allegation that, let's say, we've got a discrimination claim. And discrimination isn't even a day one right of employment. It actually can cover, and often does, the whole recruitment process. So when we're looking at discrimination, we look at the 9 protected characteristics. And I'm not going to go through all that now, but I think the ones that you probably need to be aware of are things like race, sex, religion or belief, and disability. You know, in case anybody's asking out there, and I'm sure Fiona's come across this as well, discovering your newly employed employee is pregnant is not normally a fair reason for rescinding the offer, although you may feel very strongly that that's not right. So I think for me, that sort of key process is very much about how do we find the right person and how do we make sure that they're what we want. I think the other big issue is about budget and indeed making sure that we're paying the right amount. And sometimes, I think Fiona will agree with this, our enthusiasm for getting the right person means that we're keen to pay as much as we possibly can, and we don't think about some of those hidden costs. Do you have any thoughts, Fiona, about what those hidden costs can be?
Yeah, I do. So obviously there would be associated costs of employers' national insurance contributions, pension contributions, and even actual recruitment costs. You know, it actually costs to onboard somebody, and that needs to be factored in. Alongside that, I'd probably say as well that one of the things that popped into my head, Catherine, when you were talking about job descriptions, was job titles as well. I mean, I've seen, and I'm sure you have as well over the years, quite a lot of instances where, again, an employer's been so keen to get somebody on board that they've said, yes, you can be the finance director or whatever. And actually, in reality, they're not carrying out that function, but they're expecting a salary commensurate with that sort of job title. So again, you talked about being sort of balanced and aligned, and I think that was something that popped into my mind.
Absolutely. And I think, you know, just dealing with those sort of hidden costs, these are about to increase quite dramatically. So, for example, from April, the minimum threshold for employers' national insurance that Fiona's just talked about is going to go down to £5,000, which is a big reduction. And at the same time, other changes such as the national minimum wage will also go up in April. And we need to make sure that we comply with that. Now, you might think it's quite easy to work out what you're paying somebody, but in practice, we see a lot of different types of elements of salaries, travel time, benefits, things of that type. And trying to work out whether or not you're actually paying and meeting your obligations is quite tough. I think this is important as well, that the base figure is 12.21 for everybody 21 and over, and there are different rates for other people. But it is an area where certainly, and I'm sure Fiona's going to touch on this in the moment, if we're looking at your tax and national insurance obligations as an employer, you do need to take some specific accountancy type advice. We also see clients falling foul, particularly things like pension auto-enrolment, which again can be quite onerous, particularly if this is going to be your first ever employee. Yeah. So apart from the money then, Fiona, what else do you think we need to focus on in terms of how we take a new employee on to our business?
Yeah, so I mentioned about the job title. There may be other things which need to be considered. For example, if an employee, and this may not be particularly obvious on application for the job or indeed on interview, but if an employee has or is likely to have a disability under the meaning of the Equalities Act 2010, then there's an obligation on an employer not only not to treat them less favourably than a non-disabled employee, but to consider what reasonable adjustments may be necessary to enable the employee to do the job in circumstances where they otherwise wouldn't be able to or be hindered in doing so. So that's, there's a lot of training out there for employers on how to act responsibly and deal properly with that sort of situation. But that was also something that popped into my mind, again, when you mentioned, for example, a pregnant employee or perhaps newly pregnant employee where it's not obvious that they're pregnant on interview, and that can also be the case with somebody with a disability. Of course, it may be visible, but it may not be visible, but nonetheless somebody may be a disabled person with the implications that involves. And again, it would not be appropriate either legally or, in my view, morally, to then withdraw an offer if you become, or an employer becomes aware that an employee or prospective employee has a disability.
So it's becoming a bit apparent that this is quite a responsibility to take on an employee. And the other area I wanted to really touch on, because we obviously want to try and give ourselves the best chance of it working out, is this whole question of references. References is not just a tick box exercise, is it, Fiona? It is a crucial part of the process.
Absolutely.
And who we take those references from, I think is incredibly important. We need to understand really the employment history. We need to understand what are the gaps. So references from former employers naturally have a lot more weight than, say, personal references or certainly family members. And we need to be clear. I'm going to talk about the documentation, I think, later in this discussion.
Yes,
but I do think it's important we make it clear that in our offer letter that these offers are conditional upon references that are acceptable to you as the employer. I would also suggest time limits as well, so that you don't allow yourself lots of time with somebody who's not interested in taking up the job, but also you're putting some slight pressure on them to come up with some names, the receipt of the contact details, because I do increasingly see, I don't know what you think, Fiona, is that often in this sort of situation, the individuals can go what I would call dark, and therefore we're not sure whether they're turning up or not. And so we need to have that ability to withdraw the offer, but certainly to try and progress it at a reasonable speed, because ideally you've seen the references before they actually physically turn up for work. I think there are also things that we need to look
Catherine. at. Yeah, absolutely right. And I think as well, we see a lot on kind of both sides of the fence from an employee and an employer perspective, don't we? That these days references tend to be just generic standard references. And I think, there may be a tendency to think, well, they're not much use because they don't, give details of the person's, I don't know, attendance record or ability to work with others or whatever may be objectively or subjectively included. But nonetheless, my view, which I think you've indicated that you share, Catherine, is that they are, notwithstanding the fact that they can be very generic, but they're still absolutely crucial in confirming what this person did between which dates and what job they held. Because of course, worst case scenario, a person could come along, using the analogy I applied before, and apply for a job as finance director, whereas in actual fact they've had little to no experience in that type of senior role.
Absolutely. And I think as well, depending on what sector you're in, you may have a higher obligation in terms of that referencing. So I'm thinking about care homes, nurseries, things like that.
Yeah, I've actually made a note to myself for the next section when we're talking in a bit more detail, as you just highlighted, about those sort of referencing type situations, that there may be additional obligations on specific sectors.
Absolutely. And that, I think, must be, really very carefully borne in mind.
Yes,
so
agreed.
We found the right person. What do you think we need to do, Fiona, in terms of onboarding them, in terms of our obligations as employers?
Well, I think we need to start doing some, what I would call sort of due diligence on them, don't we? And you've already highlighted, Catherine, the first step of that would be references for at least the past couple of employers, to confirm who they are, what they did, where they did it, and what their job title was. Sometimes an employer will be willing to include salary details, but it's possibly not that relevant. It's more, as you rightly pointed out, to confirm the consistent chain of employment and to identify any gaps, and therefore to potentially ask the employee or prospective employee for an explanation of those gaps. They may be, of course, perfectly legitimate, but it may also indicate something that something's gone awry, which may ring alarm bells. So that's the first step, is the referencing. They will also, another hugely, in my view, important item to check is the employee's right to work in the UK. I mean, this can be absolutely catastrophic, sorry to be scary, but for employers who take on somebody who does not have the right or cannot prove that they have the right to work in the UK, because actually it's the employer that gets into trouble for that and can be faced with huge fines. So that's absolutely imperative. There are companies out there that specialise in undertaking these processes, and it's probably right that the employer should seek independent advice from an immigration or a workplace corporate immigration specialist if they are at all unsure as to that process, because you get it wrong, it can be, as I say, pretty catastrophic, particularly for a small business that we're essentially talking about here, startups or businesses that are starting to expand. So that's absolutely top of the list, I would say, along with the referencing. We would then look at, again, this is industry dependent, but a DBS or an enhanced DBS in order to confirm whether or not the person in question has a criminal record, and if so, the extent and the impact of that. Of course, the fact that somebody has a criminal record doesn't necessarily mean that you can't or shouldn't recruit them. Their offences may be minor, their offences may be spent, and that's a whole other can of worms. But it's certainly, for some industries, it will be imperative that these checks are undertaken. And as you flagged up a little bit earlier, Catherine, there will be other or various industries that have their own specific checks on top of, as well as additional to DBS or enhanced DBS. You flagged up earlier the care sector, so that would be very important. Also financial services, so if somebody is FCA, Financial Conduct Authority accredited. In our own industry, simply checking that somebody has a practicing certificate with the Solicitors Regulation Authority, for instance. And I'm also aware that in other businesses, and financial advisors, trust planners and various people like that, that they often undertake, wisely in my view, checks on individuals who they are intending to employ. The rationale, of course, behind that being that if somebody sadly is in financial difficulty and they're working in an environment where they have potentially access to considerable or even moderate sums of money, that of course the temptation may be there to help themselves out by overstepping the market in relation to that. So that's often another check that's undertaken. So that's, I suppose, what I would call the due diligence process before, or well, we would probably say make an offer, but subject to all of these due diligence checks: the right to work, referencing, DBS or enhanced DBS, and any other industry-specific checks, a few of which I've just highlighted.
Thanks, Fiona. I mean, I think the other things that are worth thinking about, and they take a little bit of pre-warning, are if you're going to become an employer, not only have you got to go through the checks and the responsibilities that we already outlined, but there are actually some compliance needs. So, for example, you do need to register with HMRC as an employer. That should take not too long, but in fact may take up to 20 working days. I would suggest probably a bit longer.
I agree. And also on that point, on the registering for PAYE point with HMRC, you're right, it can take longer than 20 days, particularly depending on what else is going on in HMRC. But also it's important to note that registration process shouldn't be undertaken earlier than 2 months before the employee's start date. So again, it's a case of balancing not doing it too soon, but not leaving it too late.
Absolutely. And then your other obligations are you have to have employer's liability insurance. It's a criminal offence, I believe, actually not to have that.
That's right. And that has to be of at least £5 million. And importantly, it has to be with what is known as an authorised insurer. So again, it is worth our contacts out there who might be listening to this and thinking this is something that they might be looking at doing. It's worthwhile talking to a reputable insurance broker to make sure that the insurance is what it says it is and with whom it says it is.
Absolutely. And I think the other things as well are, as part of that, you will have to make arrangements for payroll and itemised pay slips. And again, that takes some time, as does this whole situation about auto pension enrolment. So these are they're not laborious obligations, but they're quite time consuming, and they need to be done as a condition before the thing kicks off.
Absolutely. And they're very important because as you say, some of them can actually dramatically give rise to criminal responsibility. And that leads me on to another couple of things which you've just highlighted. The payroll can be done, of course, in-house, but it needs to meet reporting requirements. Now, again, there are payroll companies out there that can help with that, or even a lot of accountancy practices offer that facility as well. But that is something that is important to get in place before you're even thinking about having to pay somebody. And the same with the pension responsibilities and arrangements as well. As you've highlighted, there's been in place for many years now the concept of an automatic enrolment into a pension policy, and so that would need to be looked at as well. And sort of, I suppose, ancillary to all of those things is you need to ensure that the workplace is safe. It sounds pretty obvious, but it's something that can easily be overlooked because you're a startup. Let's say you've been merrily getting on in an office, or perhaps even a home-based office or something like that. But actually then when you've got other people working for you, even I should say when they're working from home, the obligation is on the employer to ensure that there is a safe place of work. So the employer would need to be looking at doing things like risk assessments to ensure that the workplace environment is safe. And I don't just mean obviously safe in terms of there not being fire hazards and things like that, but to ensure that the workstation is appropriate, the visual display units are at the correct height and all of that sort of stuff. And again, there are specialists that can help with that. But the purpose of today is to kind of flag up that is something that an employer needs to be looking at. So health and safety, fire risks, and we also touched on when Catherine was talking about recruitment, we talked about potentially reasonable adjustments for people with disabilities under the Equality Act. And that's quite a specialist area of law, but again, it's something to be flagged up and something to consider when looking at all of these things. And then in terms of onboarding, we've talked a little bit about the immediately pre-onboarding, but then there will be various obligations once the person begins to come on board, which I think Catherine and I are going to look at now. The first of which, and again, this will predate the onboarding but continue into that onboarding process, is a data protection policy which will govern how the employer collects, stores and processes information about, lots of people they deal with, including prospective employees, but extending to others as well.
Absolutely.
We've got our ideal person. We've sent them the offer letter subject to these conditions. The conditions are all being met. Everybody's happy. we want them to start. What do we do now?
Well, first thing we need to do is we need to confirm with them that they are going to start. That may seem obvious as well, but I'm always staggered how often people don't
Good point.
agree those arrangements for when are they going to start, where are they turning up to, and do we need them to bring in any proof of our documentation? So if they're a solicitor, do they have a practicing certificate? Or do they have to, we want to see the qualifications that they've actually put together? So there's quite a lot of pretty straightforward stuff, which it's easy to overlook. I think the other big area that I want to focus on now is in relation to the sort of whole contractual terms piece.
Yes.
There isn't an obligation to provide a written contract, but there is an obligation to provide written particulars. And generally speaking, those are pretty much, for practical purposes, the same document. Unsurprisingly, they set out all of the key terms. So I don't know what, Fiona, you would say were key terms, but they would be the things that you would think were obvious, like what hours are they going to work? Where are they going to work? How much are they going to get paid? Are there any specific terms about probation? They have to provide access to a disciplinary policy, a grievance policy, and indeed sickness terms. They can be provided by reference to another document. And I don't know what Fiona thinks, but I think sometimes it's better to try and avoid putting everything into the written contract of employment or particulars, because I have a horrible feeling that nobody ever reads them.
Agreed.
I think, if we
Agreed.
can
And then in
cross-reference.
the worst case scenario, if there's a disagreement further along the line, it makes it more difficult to say, well, look, it's in the contract. I mean, we were talking about the statement of terms, and I think that's right. It will often depend, won't it, Catherine, I suppose, on the employee as well, and whether there are additional terms that an employer wishes to agree with the employer.
Absolutely. And I think that's a part of it, is that about seniority. But certainly if you're introducing things like post-termination restrictions, you do need, this isn't just a plug for more work, you do need more advice on that.
Yeah.
Because if you don't get that advice, and let's say there's a massive mismatch between the post-termination restrictions when they're not going to come after your customers and the notice periods, that's going to have quite an effect on enforceability. So it isn't a plug, but it is very important. For a more junior employee, I think you could go for something a lot more straightforward and arguably short. I think sometimes generally our contracts are too long and people don't read them, and the important terms are too buried. So I think that's a really important point. This is a living document. We may very well need to change it in the future. It may adapt. So there's also an issue about which bits are contractual in legal terms and which bits are discretionary. It's obviously a lot easier to change the terms of a discretionary provision
Yeah.
than it is a contractual change. Generally speaking, though, if we're going back to those particulars, the key things like pay and place of work are generally deemed by the tribunal to be contractual. So it's really important that we understand that before we issue those documents out. I
Definitely.
don't know what
Yeah.
Fiona thinks as well, but I'm quite keen on people signing these documents to prove that they've had them, they've
I
read them,
totally
and then
agree.
returned them.
Yeah.
But we're not very good at following that up.
No, that's right. And Catherine, you and I'm sure, have both seen over the years that we've been in practice combined, that quite often, and then somebody will say, well, I haven't signed it, so it's not binding. That's not necessarily correct, of course, because if an employee and indeed an employer have worked together broadly under those terms for a period of time, then that probably will apply. But it's just so much more straightforward to make sure that both parties have signed it, or at least the employee has signed it to say, yes, I've got it and I acknowledge it and I agree with it. So Catherine, you mentioned as well, when you have perhaps not all singing, all dancing contract, or even when you do, what policies you might refer to that appear outside that.
Absolutely.
You mentioned
the obvious
disciplinary
ones.
and grievance.
Sickness, I think, generally is usually out with the contract or the particulars. The other things, we have a lot of leave policies now. So I'm thinking about maternity leave, parental leave, shared parental leave, paternity leave, bereavement leave, neonatal leave. I mean, the list goes on. I think because there is such a lot of change in that area, I personally feel that is best dealt with out with the contract, makes it easier to amend and easier to update. My only slight concern about that, and I'd be interested in Fiona's view, is that I myself have worked in firms where it was felt that they would never show you what the maternity policy was because they didn't really want you to know. I don't really think that's particularly helpful. I
Agreed.
want the things to be accessible.
Yeah,
I think the use of things like the intranet is fantastic for that, because
definitely.
policies used to sit on shelves in HR offices. They don't sit on shelves anymore. They sit on the intranet. And it is that whole question, don't you agree, Fiona, about accessibility?
I definitely do. It's accessibility, it's transparency. We're going to talk briefly a little bit later about what's in the future, but I was looking at something the other day, which is another further introduction to a new type of leave, which is for survivors of domestic violence who are leaving an abusive situation. And there's a bill going through Parliament currently to look at whether an employee will be entitled to 2 weeks paid leave to facilitate or to assist them in a situation of that. So as you rightly say, these things are changing and evolving all the time. Sometimes an employee might not know what those rights are unless they're published. As you were saying, going back to maternity leave and adoption leave, for instance, when that became law, people sometimes don't know what it is. And so, yes, I share your view that that's important, that it's somewhere that somebody can think, oh, what's the situation there, and click onto it and have a look.
Absolutely. I think that's really right. And hopefully, probably 9 times out of, 10, you'll never have to deal with them. But it's
Indeed.
so good that you've got the policies there. So when it crops up, you can easily access them. And that isn't just about providing, I think, clarity for the employee, but also for you as the employer. It's protecting
Definitely.
you because it's giving you a good roadmap, really, as to quite how to deal with things. And dealing with anything for the first time, I think, is always particularly difficult. So if we go back to the theme of this talk, this is a whole new chapter with a new employee. So you do need to be well armed, if you like, with exactly what the policies and the procedures happen to be.
Definitely. And it's often, I think, we've seen this, haven't we, Catherine? It's often the case that, this is all new, as we were talking about, which is all new, it's exciting, can be a bit daunting, particularly if somebody, for example, has never employed anyone before, has only been an employee themselves
Absolutely, because it's
until
very
now.
different employing somebody.
Very different. And it will depend on that person's own experiences as an employee, I guess, as to, what guides them towards, how to be and what to publish. But certainly, as you say, if you've got those policies in place, you as a new employer will have a roadmap or a reference point to think, there's this situation. What do I do about that? What about, I don't know, holiday entitlement or working time or all of these types of things. So I've just touched on 2 other policies that we might think about as well there, haven't I?
So, I mean, obviously, there is quite a lot to cover off. I think our sort of final points are you may be encouraged to, as an alternative to employing people directly, going down what we call the self employed contractor route or worker route. Those have benefits and obviously are beyond the scope really of our
Yeah,
discussions today. But I think if you do want to go down that route, don't forget that that also can be quite complex legally. So, for example, workers may not have all the rights of an employee, but they have quite a lot of rights.
yeah,
Also, I think, and I don't know what Fiona feels, but we are in a state of some change. So we know that there will be big changes ahead going forward. Autumn 26 seems where the good money is.
yeah,
But there are going to be a lot of changes in relation to that. One of which actually is to stop having all these different types of employee worker and having a single status. So I think that's really important. And then the other one for me is the extension of what we call day one rights. So I said,
yeah,
as part of the recruitment process, an individual might still have the right to pursue a claim if they're discriminated against. But this is going to be extended. So in terms of day one rights, if we're looking at miscarriage leave, protection against unfair dismissal, again, that is a lot of change and you
huge.
would need to be ahead of that.
Yeah,
Anything else?
that's right. Yeah.
So I don't know whether Fiona wants to add anything else to that, but we hope we've given you some food for thought. And I suppose if you take nothing else out of our discussions, from my perspective, certainly, it's you need to just, it's not scary, it's really exciting, but you just need to be well prepared.
Yeah, definitely. And I think that all that I would add, Catherine, is just for our viewers' benefit, that this is the current situation now, as Catherine has just highlighted. I think we've calculated or worked out that there's going to be potentially at least 30 amendments to the employment law as we know it today, some of which is starting quite quickly, some of which will be later in the year, some of which is still being mooted, the bill that I mentioned earlier, just by way of example. So watch this space. We will be providing updates on employment law and regulatory law as that affects you, as the changes become clearer as to what they're likely to be. So thanks for watching.
Thank you very much.